Ya kate karai ke Iing Dorbar kalau Mynjur pada kejeng persya ke bejur bahan ke yang persya khamtam iki katu kat ni ke MLA ki bawat lang kum ke MDC shwa kani ke MDC kan thup nadu ba ki pi panyang ba ismi nong se ba adan embassy ba met ba ling do wat la kila pen pau ba kim persya ya kate kejeng thmu jong sarkar handai ki kerpat pat bala kumnu kan ailat hadu bandakut kani ke samai kata bentrekam nadu ke sitarik ulabea jong usnam azak khandai handai halor kani nakaliang menteri rang ba dok mukul sama buat kumjuru menteri ketanat law ba rawling do kila yang skam ba kejingwan ra ya kate gabel kade namar ladon kam kerke bat kumta kila kwa bentrekam no nadu urusaw mentau usnem hang ni singi kite ke MLA ba de ke MDC ru kila pen pau bala dak sarkar kaya ibet ya kate karai kalong kumbale ben yik pat ba nong krishan ki blanjet but ibet eki ban Mihkhmat kum ke MDC.
Speaker sir, I personally welcome the prevention of disqualifications members of Legislative of Meghalaya Amendment Bill 2015 to be implemented in the state of ours in due course of time. Speaker sir, at the time of the filing nominations, no law has restricted them, legally permitted them to contest MDC. But suddenly saying that you are illegally elected. What is this? Is there any hidden agenda? Why government want to implement this bill in harsh, as if the world will be ended tomorrow? A newly marriage couple, though they want to get a child, but they have to wait at least a year. Speaker sir, election is election. Involves many things: physically, financially, mentally, stress and strain. Hence, sir, in humanitarian ground, I urge the government, please allow the member of the district council to complete the term gracefully.
So anyway, I would like to refer to some important points which I feel should be taken into consideration while moving forward. Sir, I've gone through the bill yesterday, and it really surprised me when I go through the statement of object and reason. I'm not saying yesterday. The way it is prepared, it is done in a hurried manner, without any proper thinking how to write this object and reason. Sir, if we go through the original act 1972, what is the purpose of the act in para 2? The purpose is the removal of disqualification in certain areas, which means that person shall not be disqualified or shall not be deemed ever to have been disqualified for being chosen as or for being a member of the Legislative Assembly of Meghalaya by reason of the fact that he holds any of the offices specified in the schedule, insofar as it is an office of profit under the state government. Initially, yesterday, when the Chief Minister told us that they could direct the governor and governor direct the government, first thought is that there is compulsion. But when we think it properly, I'm fully convinced that no court can direct the government to amend the law. especially when the case is pending.
Amendment Act, there is a general sense of apprehension and also agitation on the part of members of this House, and more especially on the part of the members who will be directly impacted if this bill were to become an act. But apart from this sense of apprehension and agitation, sir, I also feel a certain amount of relief when I look at the visitors' gallery and I don't see the school or college students there.
Please don't refer to visitors' gallery.
I don't see school and college going students there. Sir, why? Because when I go to this statement of object and reasons of this amendment bill, sir, which speaks about the prevention of disqualification, the Department of Law has even split the word disqualification. This sentence says, nominated to such a district council by the governor is not attracted from this qualification, THIS, this, and then qualification. You know, this qualification is one single word, sir, and when it is split in this manner, the meaning is entirely different. The intention, the next sentence says the intention. I do not know who drafted this piece of legislation, sir, this bill. The intention. The next sentence says, I do not know, I cannot comprehend what it means. Maybe my other friends can also give their input. The next sentence says, the intention of this provision is only to them to contest the election. I do not know what kind of English is used here, sir, because it makes no sense, not something that can be easily understood. And to say that it's an act done in haste is in fact an understatement. It seems to have been rushed in such a manner that even the basic task of checking grammar and spelling has not been done. And this is important because it reflects the utter lack of seriousness and professionalism of the state lawyers and counsels. It says, during the course of the proceeding today, when we wanted to dispose of the matter after hearing the State Council, we are surprised to find none present for the state, and thus there is no representation on behalf of the state. Needless to say that the state panel of lawyers in High Court is headed by Advocate General Mr. K.S. Kinjing. As per regular feature, the Advocate General either remains absent or if present, renders zero assistance. The position of other government lawyers in High Court is also not any different. We wonder as to on what basis Mr. K.S. Kinjing was designated as senior advocate by the Guwahati High Court, for he appears to have very little knowledge of law. We have also been noticing that most of the government advocates are only interested in taking adjournments on the ground of their personal inconvenience or that of the officers supposed to pursue the state matters. This is happening despite the fact that they are being paid professional fees and retainer from the public exchequer, and 90% of such money is coming to the state from the central government. Thus, we are constrained to bring this matter to the notice of the Honorable Chief Minister Meghalaya for his perusal and appropriate necessary action. I think this sums up why we have this problem today. and why this bill is necessitated. If the High Court says that the state, so I cannot use language which can be more damaging to the state law department than this observation, that even your AG seems to have very little knowledge of the law, pleads for adjournment, and this is reflective of why pressure was built on the Chief Minister, which is what this judgment says on a different matter. Therefore, sir, I think that the MDCs are only being made scapegoats, collateral damage of the facts of the non-performance of the law department, which in this case has even split disqualification, a single word, into THIS, this, and qualification. Sir, this is indeed a matter that needs a lot of reflection, a lot of input, a lot of debate.
Mr. Speaker, sir, for me, sitting on this opposite side of the bench, being in opposition, just to oppose and keep opposing everything whatever the government is doing, I think it's wrong. We are here as a member of this House with responsibility and accountability. We are here to contribute to the betterment of the state of Meghalaya. We should not play a negative role or having with a negative mindset all the time. Fighting election is not a small matter. We all know. With pain and a lot of things which all the members have expressed, with a lot of stress, pain, for me no tension, tension is not there. But after winning, we are here, and I'm sitting in this chair and standing here, not because of Ahmed Balindo. I just represent the 30,000 electorates of my constituency. Those people are sitting here in this chair, not Ahmed Balindo. This is what each and every one of us as a member has to realize. Who are we when we are here in this floor of this House? Whatever words, a single word to speak, we have to be careful. Whatever things that we would like to do, we have to be careful, because we are responsible for whatever we are doing for the people of the constituency first and the state as a whole. That's why, sir, I agreed in 2014 to contest the MDC election, because this provision of law, 1972, no need to go down into what it says. But the title of this act itself is very clear. The Prevention of Disqualification, Members of the Legislative Assembly of Meghalaya Act, 1972. That itself, prevention of disqualification of the members. Well, yes, when it comes to Para 9, which allows the chairman, the executive member, CAM, and any other honorary member of the district council to be at the same time a member of this August House and member of the district council.
Sir, yesterday I had to express my mind that though we all agree on the intention of the government to bring this amendment, however, we cannot accept that this amendment will be effected from next month, as mentioned in this amendment, sir. So, yesterday I had expressed about the justification, whether it is justified or not to pass this amendment bill today. And also after I have read the court ruling, which has been stated by the honorable member from Shillong West regarding the order given by the High Court on the quality and competency of our AG and the panel of lawyers that the government have put in place, I question myself whether this bill, which the government is supposed to pass today, will be legal or not. I would like to stress on the legality of this bill. Can we rely on the advice of an incompetent AG to take up this amendment bill? So, sir, maybe the government can rely, but as responsible public representatives, especially after we had gone through this order, we feel that we are full of doubt that this bill will not be challenged in the court of law. So I feel that if the government is going ahead with passing of this bill, we are only opening up a Pandora box. Here in this house, I feel we are going to lose some more members. We have 2 doctors who are professors in the Northeastern Hills University. If the MDCs for so long are allowed to be both MDC and MLA, so is the case with the professors in NEHU. They can be both professors and member of this house. So, do you mean to say that from now on, professors from NEHU cannot be the member of this house? So, sir, therefore I would like to suggest, leap upon the wisdom of the MDCs to deal with the court. Since the matter is being taken up in the court of law by an individual, and every MDCs have also response to that case, so why not leave the matter in the decision of the member? Because if the High Court is going to issue an order to disqualify the MDCs, this is not the apex court. There is still another court, a High Court, where we can go to the apex court for appeal. So therefore, sir, I feel it will be a great injustice on the part of the government, to simply follow the instruction. Because as one of the members has mentioned, that we are a parliamentary system of governance. So in a parliamentary system of governance, there are 3 main organs, where we all know: the legislature, the executive, and the judiciary. It is the job of the legislature to make law, and the job of the executive to execute the law. The job of the judiciary, in fact, is only to see that the interpretation of law are legal, are in proper way. So therefore, I would share my concern and submit my submission and request the government, if at all we decide to pass the bill today, but let it be effected at the expiry of the term, sir.
Sir, the question of holding 2 posts constitutionally is illegal. Under the Constitution, the provision of Constitution, the elected member cannot hold dual posts. This matter has come to the attraction of the three governors, according to because I had a chance to be in the government as the Chief Minister also. We know the way of thinking, right from the former Governor Musubasuri, Dr. K.K. Paul, the present one. They have got the attraction of this. But at that time it's not serious, it didn't come openly to the limelight, to the newspaper, to public debate. Fortunately or unfortunately, this time it came out like that. And it's gone even, someone went to the court, Honorable High Court. And we understand, well, in spite of the deficiency or inefficiency of the AGs and all, but you have been told that the case has been entertained by the High Court. And the process going on, they may take decision sometime next week or some other day. Question here is, if the Honorable High Court, in its wisdom, will disqualify those members who hold dual posts, I mean, the very sure effect will be against these members holding it. We cannot presume the decision of the High Court. These days, the decision of the High Court, Supreme Court, you would see how much he had infringed, or what to say, had involved into the admission that they have to follow. Directive to the government, directive to, but so here is another case that it is in the file of the Supreme Court to take a decision. We may say that we may go to High Courts or Supreme Court, Apex Court and all, but the facts remain, if they have decided that they are disqualified, immediately it affects all the members sitting there. Sir, with this, I have my doubts that the question of bringing this bill does mean to target someone, and I do not see that it is a man-made thing to do just now. Why we keep all this? Just now, description have become urgent. That the matter looks to be taken seriously, this matter. So the government, its wisdom and also the consultation with the Law Department, you can say anything to the Law Department, but our Law Department and the lawyers have been going all through. Yes, there may be deficiency, there may be lapses, omission, commission, but at least we have to work with them and not wholly to the Law Department. The government's whole also involved in this. You cannot wholesale say that the whole cabinet are not efficient. Because of one deficiency of the officer, the whole thing should go wrong. So the government might have exercised its mind that they bring this amendment bill, as I said today.
Mr. Speaker, sir, we refer to the constitutional provision. We got to have a complete clarity on what is the provision of Article 191 of the Constitution of India. I would like to share this particular portion, which was also read by the Honourable Mover of the amendment. Article 191. Of Clause 1, starting, a person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of the State. A. Subclause A. If he holds any office of profit under the Government of India or the government of any state specified in the first schedule, other than an office, I repeat, other than an office, not office of profit, other than an office declared by state legislature, by the legislature of the state by law, not to disqualify its holder. Not to disqualify its holder is pertaining to other than an office, not office of profit. Mr. Chairman, sir, we'll have to read between these two, office of profit and other than an office. Now,
Therefore, if this particular serial in the Act in question for which the government has brought an amendment for correction, it has to be understood from this particular interpretation of the constitutional provision in respect of Article 191, Clause 1 and Subclause A, Mr. Speaker. Then we refer to Article 190. No person shall be a member of both houses of the legislature of a state, and provision shall be made by the legislature of the state by law for the vacation by a person who is chosen a member of both houses of his seat in one house or the other. Now, the spirit of this particular Article 190, we are not talking about an office other than the office of being the legislator of this August House, which is incorporated as other office, but not as office of profit. Here, we're talking about the post held as a legislator of this August House, and also another office of profit of another elected house, which is also assigned with the responsibility, constitutional responsibility of legislation. Legislation. The responsibility of members of the district council are also for legislation, Mr. Chairman, sir. Not other posts which can be referred to, which are contained in this act, for which the other serial numbers have been incorporated for prevention of disqualification of the members of this Legislative Assembly, Mr. Speaker. Therefore, I would like to reassure this August House that this measure of the government is for the purpose of setting things right, in sync with the spirit of the provisions of the Constitution of this great nation, and also to enable us to ensure that we are able to confront the situation effectively without being caught unaware. On the other aspects of circumstances, I would not like to further elaborate, but I would like to urge upon all the members of this August House that please understand the situation. Having understood our own responsibilities and having agreed that this move is a correct move, only the timing. But the timing as such itself is important, and if timing was not important, then the request to seek the sense of the House to extend the sitting of the current autumn session would not have even come, Mr. Chairman, sir, if there was no exigency of the situation. The exigency is there, and it is with complete honest intention of fulfilling our legislative responsibility. And if we do not do this, we will be seen as members of this August House who were caught unaware and who were not prepared to take corrective measures. Therefore, Mr. Chairman, sir, I appreciate the sentiments, I share the sentiments, but at the same time, I think we are also equally privileged that if we are already having both the post of MLA and MDC, we will be still serving the same people in the capacity of being elected member. Only one of the posts of being elected member, one has to decide, Mr. Chairman, sir. So where is the question of being not able to serve the people whom we represent? We will continue to serve them. I see many of our friends from this August House who were together with us in the preceding houses who are no longer members, but they continue to serve. Many of the members of this August House sometimes do not get the mandate from the people to represent continuously in the successive terms. But people again elect and send our people back. We are so privileged because people keep on giving us these privileges, opportunities. And even as elected or not elected, once we are politicians, once we have taken the decision to serve the people, I think there is no going back. We continue to serve the people. It is only the politicians who never retire in life. We continue to serve people, whether while being in office or while being not in office. Therefore, sir, there is no space for us to say that we will not be getting the chance, opportunity to serve the people whom we love so much. We will continue to serve them. But I think there is a time that when we know that we need to correct, why wait? So, Mr. Speaker, sir, with these few words, I'd like to make it clear that this intent of the government is to actually fulfill the responsibility of being members of this August House in as far as our legislative responsibility is concerned.
This amendment which we have brought is in a correct time and it has to be done. Otherwise, if, as I said, if there is any judicial scrutiny, then will be found lacking and the whole bill may be thrown out. Therefore, sir, with the good intention which has already been set, we have to bring this amendment bill. And therefore, there's no need of any prospective timing, but the bill which we have brought is quite enough and it suits everybody. Though it has affected, of course, some of our members who have been elected as MDCs, but that cannot be helped because we can foresee the greater interest of the member of this House. So, sir, with this few clarification, and as our Chief Minister has already clarified many points, I would request the Honourable Mover of this amendment to the amendment bill that he may kindly withdraw his amendment.
May I know the mind of the Honourable Mover whether he will withdraw his amendment?
Mr. Speaker, sir. Thank you very much for the clarification. Our state has been lasted now for more than 43 years, sir. But what I make you to not to convince with the clarification from the Treasury bench is that what is the urgency? What is the urgency to bring this Rushy amendment bill? To the prevention of disqualification members of the Legislative Assembly of Meghalaya Act 1974-72, entry number 9. Sir, I also wonder why the government of the day, they are very worried about the pending verdict or judgment of the Honorable High Court. So, sir, I once again appeal and pray to the government of the day to kindly accept the clause 1, subsection 2 to be instituted as follows. It shall come into force with effect from 1st March 2009, because we don't oppose the whole portion of the bill. We appreciate the principle of this bill, but only this portion. The effective period of this bill shall come into force on and from 1st March 2019, sir.
Since the honorable mover of the amendment has not withdrawn his amendment, now I'll put the question before the House. The question is that the amendment to the bill be adopted. Those who are in favor of the amendment say aye. Those who are against say no. No. The noes have it. The noes have it. The amendment to the bill is rejected and lost. I'll now put the main question before the House. The question is that the prevention of disqualification members of the Legislative Assembly of Meghalaya Amendment Bill 2015 be taken into consideration. Those who are in favor of the bill say aye. Aye. Those who are against say no. The ayes have it. The ayes have it. The motion is carried, and the motion for consideration of the prevention of disqualification members of the Legislative Assembly of Meghalaya Amendment Bill 2015 is adopted. Now we come to item number 7, Shri Royal Lingdo, Deputy Chief Minister in charge, law to move that the prevention of disqualification members of the Legislative Assembly of Meghalaya Amendment Bill 2015 be passed.
I beg to move that the prevention of disqualification members of the Legislative Assembly of Meghalaya Amendment Bill 2015 be passed.
Motion moved. Now let me put the question before the House. The question is that the prevention of disqualification members of the Legislative Assembly of Meghalaya Amendment Bill 2015 be passed. Those who are in favor of the motion say aye. Aye. Those who are against say no. The ayes have it. The ayes have it. The motion is carried, and the prevention of disqualification members of the Legislative Assembly of Meghalaya Amendment Bill 2015 is passed.